Hi there, welcome to Help Solve the Case. My name's Christine Burke, and we are here for part 4 of the Karmelo Anthony request for a new trial. We've been following what the defense filed and learning why they feel that they need a new trial. Now, if you don't know me, I'm going to pull that up here. I love everything court related, and I like reading the pleadings and giving you my honest reaction. And so I'm glad you're here. We also do on this channel, let me fix myself here with the layout. We also do on this channel, my goal is to raise money. I'm a forensic genetic genealogist, if you don't know me. And my goal with this channel is to raise money to do more cases, solve more cases, identify our unknown humans using forensic genetic genealogy and other means. And that's why we're here. And so I appreciate you being here with me. Okay. So first here, we are starting on this part here, number 64. The order fails the Waller test at every step. And this Waller is a precedent. Okay, this Waller that they're talking about is a precedent that sets the rules about what needs to be in place so that judges can restrict or close the courtroom. And according to what the defense has said here, they've talked about a lot of cases, Stricker, another case too, about it has to meet some sort of a threshold to be able to override what they say is the constitutional right to have the public watch and be present at the trial. Okay. And in this case, if you haven't seen the other videos, the defense is saying that the public was a significant amount of the public was barred from the trial. There was only so many seats. They didn't do the audio feed. They didn't do the video feed. And they had that access. They had over what they're calling overflow access during the jury selection. So why, if they had it at the jury selection, did they not have it for the trial? Okay. But as I mentioned, this Waller precedent outlines certain standards that need to be met. Okay. So here it says the first Waller factor was never satisfied by anybody. That factor requires, quote, the party seeking to close the hearing, end quote, to, quote, advance an overriding interest that it is likely to be prejudiced, end quote. And in this case, in the prior videos, we've talked about how the defense is articulating here that nobody asked for it to be closed, neither the defense or the prosecution, and that the judge just issued an order on their own. Typically, we see the defense, when we see this word prejudice, we see the defense requesting closure, okay? Like we've seen in the Tyler Robinson case recently. But they go on here, they say, here, no party sought closure, no interest was advanced by any proponent, and because the court took no evidence, no interest was shown to be likely prejudicial because the court didn't even entertain anything. They just said, poof, here's the rules, okay? They say the court's generic recitals cannot supply that showing, and a court may not relieve itself of the burden by acting on its own motion. And they'd say, to the contrary, Presley v. Georgia, this is another case that they've brought up a few times. The trial court excluded the public from voir dire, that's the jury selection, on its own motion, and the Supreme Court reversed precisely because a trial court must satisfy Waller and must consider reasonable alternatives even when the parties do not propose them. That's a big sentence there, okay? The remaining Waller factors fail as well. These restrictions were broader than necessary, a fixed numeric cap on attendance, a 10-minute public entry window, and the categorical absence of any overflow accommodation swept more broadly than required to protect any interest the court identified. And the record does not reflect that the court considered any reasonable alternative. An overflow room with a closed circuit audio or video feed, a larger courtroom, or staggered or reserved public seating, as Presley required it to do even on its own motion. Okay, and they're citing that precedent there. The order's finding cannot bear the weight the Sixth Amendment places on it. Okay, that's the constitutional, U.S. Constitution. The court did recite findings that the case quote, has generated substantial public and media attention, end quote, and that, quote, unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, end quote. But findings of this kind are legally insufficient. They identify only generalized categories of concern, not the specific concrete facts or articulated threat that Waller and Presley require. And the word, quote, may confirms that the court identified a speculative possibility rather than a demonstrated risk. The Court of Criminal Appeals rejected materially similar findings in Stedman, another case they've quoted, where even detailed findings of, quote, heightened security concerns and potential juror discomfort were held insufficient because they were generic and identified no, quote, specific threat or incident, end quote. Findings, quote, specific enough that a reviewing court can determine whether the closure order was properly entered, end quote, are, quote, the linchpin of the Waller test, end quote, and, quote, generic findings will necessarily invalidate a closure, end quote. Okay, so there was no specifics. It was just they thought or whatever, okay, because there may be, who knows, is anything possible? These findings are not only generic, they are unsupported because the court received no evidence. The court held no evidentiary hearings on the restrictions, took no testimony, and admitted no exhibit concerning courtroom capacity, security, juror privacy, or the risk of prejudice. Findings on those subjects made without any evidentiary basis rest necessarily on either the court's own assumptions or on information outside the record, neither of which can satisfy the burden to justify a closure or support findings the defendant had no opportunity to contest. The distinction governs review. Okay, so they're asking it. An appellate court defers to a trial court's findings. In fact, sorry guys, I don't know what's going on. Tongue-tied today. The appellate court defers to a trial court's findings of fact only insofar as they are supported by the record, which they're not on the record, they're saying, and findings without evidentiary support receive no deference. Okay, they're citing Cameron. Nor may the deficiency be cured after the fact by post hoc assertions. The closure stands or falls on the findings the court articulated when it acted. Okay, and that they're talking about the order that the judge provided. And the order's own recital, they say, that it affords, quote, reasonable public access consistent with constitutional requirements, end quote, cannot be reconciled with its operative terms. A 10-minute entry window, no overflow, and no live stream, which demonstrate the opposite. The court's post-trial interview supplies no cure for these deficiencies. I believe they're talking about when the judge went on TV. There, the court suggested that the presence of minor witnesses justified limiting public access. That rationale appears nowhere in the court's contemporaneous findings, and a closure cannot be rehabilitated by a justification offered only after the fact. The adequacy of a closure is measured by the findings the court articulated at the time, which must be specific enough that a reviewing court can determine whether the closure was properly entered. And they're going to cite this case, again, Press Enterprise, Waller, Presley. They say the rationale fails on its own terms in any event. The Supreme Court has squarely held that even the compelling interest in protecting minor victims of sexual offenses, a more sensitive concern than the mere presence of minor witnesses, does not justify a rule of mandatory closure. Protection of a minor must instead rest on a case-by-case determination supported by particularized findings that exclusion is necessary to a specific witness. They cite Globe newspaper v. Superior Court. Okay, and this sounds like we're going over a lot of redundant stuff, but they are like putting what I believe any potential opportunity in here for them to, well, what about this? What about this? What about this? So they're hitting all these potential concerns. Okay. It says, a generalized concern for minor witnesses could therefore support at most a narrow measure addressed to particularly, oh God, sorry guys, to particular testimony, not a fixed seating cap, the elimination of overflow, and the denial of any live stream across the entire trial. Texas law confirms the point. Even in juvenile proceedings in which a child stands accused and faces adjudication of delinquent conduct, the court, quote, shall open hearings, to the public unless the court, for good cause shown, determines that the public should be excluded, end quote, and talks about Texas Family Code. And only for a child under the age of 14 must the court close the hearing, and then only, quote, unless the court finds that the interests of the child or the interests of the public would be better served by opening the hearing to the public, end quote. If Texas keeps open even the proceedings in which a minor is the respondent, the presence of minor witnesses cannot warrant closing this adult criminal trial to the public as a whole. Finally, the order applied the wrong constitutional standard. It characterizes the restrictions as, quote, reasonable time, place, and manner restrictions, end quote. The standard that governs the regulation of speech in a public forum. That is not the standard for excluding the public from a criminal trial. Reasonable measures that merely administer the courtroom may be permissible, but the provisions that exclude the public, the 10-minute window, space available seating behind the media cap, the no reentry rule, and the absence of any overflow affect a closure governed by Waller and Press Enterprise, not by the more lenient time, place, manner test. By treating an access closure as a time, place, manner regulation, the court applied a less demanding standard and bypassed the findings Waller requires. The order's reliance on Shepard v. Maxwell does not assist. Shepard concerns a court's duty to control prejudicial publicity and press conduct to protect a fair trial. It does not authorize excluding the public from the courtroom. They say a standing order is no substitute for an open courtroom, and every reasonable alternative was ignored. The form of the court's action independently offends the public trial guarantee. The restrictions were imposed not by case-specific, evidence-based findings developed at a hearing, but by a preemptive written standing order, the amended order regulating trial proceedings, adopted in advance to govern, quote, all aspects of the trial proceedings, end quote. The Office of Court Administration in published guidance grounded in Waller, which means it's sprung from, built around, and its Texas progeny, has explained that, quote, no standing order or global rule for closure of specific categories of hearings may be preemptively issued by a court without running afoul of the requirement to provide the public with access to court proceedings, end quote. Because the court must instead, quote, consider all reasonable alternatives to closing the proceeding and make findings in open court on the record adequate to support the closure, end quote, weighing the, quote, totality of the circumstances, end quote. Office of Court Administration, they talked about that there's a document there, and it says the court's standing order did precisely the opposite. The trial court is obligated to take every reasonable measure to accommodate public attendance at criminal trials, and the burden of doing so rests on the court itself. We're citing Lilly again, and Lilly quoting Presley. Texas courts have a proven, readily available means of discharging that burden when in-person seating is limited, real-time public access by audio or video live stream. During the COVID-19 disaster, God, remember that? Whew. When shelter-in-place orders made attending a hearing in person a punishable offense, the emergency orders of the Supreme Court of Texas required that proceedings continue with, quote, reasonable notice and access to the participants and the public, end quote. And courts throughout the state discharge that obligation by live streaming proceedings to the public. So again, I think they're saying, for goodness sake, if you could do it for jury selection, why can't you do it now? And if you could do it during COVID, why can't you do it now? Why didn't you do it now? If a declared statewide disaster did not excluding the public, but instead required courts to bring the public in by other reasonable means, then the comparatively ordinary demands of public interest and courtroom security cannot justify excluding members of the public here while offering no alternative at all. Okay, so I think that's a good statement there, right? So here, the judge has given us no evidence or given the defense no evidence. The judge just issued the order, didn't hear it, didn't do anything about it. But they're saying here, the defense is saying, if a statewide disaster forced them, was reasonable enough that they still had to do it, then the potential for whatever the judge thought was going to happen, that's like, no comparison, right? That's what they're saying. The court provided no overflow room, no audio feed, and no video live stream, and the record does not reflect that they considered any of them. These alternatives were neither novel or untested, which is true. I'm doing it right now. Across the country and in Texas, courts confronting public interest as intense as this case or far greater have kept their proceedings open by ordinary means rather than closing them. State courts may permit camera and live audio video coverage of a trial in the trial court's discretion. They quote Chandler v. Florida. Texas courts have repeatedly used that discretion to keep even the most charged criminal trials fully open. In the 2019 Dallas County murder trial of Amber Geiger, I didn't see that trial, but I remember that case. A police officer, the trial court permitted the entire proceeding to be live streamed from the courtroom and the public watched in real time. Only months before this trial, the first criminal trial arising from the Uvalde school shooting response was moved to a Corpus Christi courtroom chosen in part for its capacity to hold the parties, the victims' families, and the national media, and was kept open gavel to gavel by live stream coverage, a designated media room, and overflow space during jury selection. The occurrence and public character of these proceedings are documented in widely available reporting, and they cite some of that. So I don't know. What do you think? Like, it's crazy, right? Here we go again. The nationally watched murder trial of Derek Chauvin is a useful illustration, and I watched that one. I watched because I wanted to see the law enforcement experts and what was going on with that, right? So I watched that one. Every factor a court might invoke to justify restricting access was present there. Extraordinary public interests, witness safety concerns, and pandemic limits on in-person seating. Yes, that was right. Crazy times at that time, right? Yet the court did not exclude the public. When the state proposed to rely on overflow courtrooms and closed-circuit cameras instead of broadcast coverage, the court rejected that proposal as inadequate, holding that audio and video coverage was, quote, the only reasonable alternative to ensure a truly public trial, end quote. And that's the State v. Chauvin. The court authorized the entire trial to be broadcast and live streamed, declining only to show juvenile witnesses or the victim's family on camera. The contrast with this case is stark. The overflow viewing by closed-circuit feed that the Chauvin court deemed the constitutional floor. Remember, they talking about in prior videos, we're talking about foundation, okay? The constitutional floor, the bedrock, okay? What the rest of it's built on, and found inadequate standing alone is more than this court ever provided, for here there was no feed of any kind. The principle holds even where broadcasting is forbidden. The federal courts prohibit photographing or broadcasting any proceeding from the courtroom. Isn't that interesting? Yet they keep even their most security-sensitive prosecutions open by first-come, first-served seating and overflow rooms carrying live feeds inside the courthouse. The January 6th Capitol cases and the Boston Marathon bombing trial proceeded in open court with the press and the public present, and in marquee federal trials whose main courtroom could seat only a fraction of the public. The prosecutions of Samuel Bankman Fried, and Ghislaine Maxwell among them. The courts opened overflow courtrooms carrying live video, and in Maxwell's case, a nationwide live audio feed, so that the bar on broadcast became no bar to access. They're like tongue in cheek there. A no-camera state forum did the same. In a nationally prominent 2024 New York criminal trial, where state rules forbid cameras, the court kept the trial open through an overflow room, carrying the proceedings on closed-circuit television. What none of these courts did, facing public interest and security concerns equal to or greater than those present here, was admit the public for a single 10-minute window, bar re-entry, and then deny any overflow room audio feed or video access whatsoever. And they cite all these sources. These comparators are not controlling authority. They are not offered as such. Okay, they're saying that these trial comparisons are not controlling cases. Okay, they're not citing them as precedent. They're just illustrating it. They are offered for the limited practical point that reasonable alternatives were familiar, available, and not speculative, right? Judges can call other judges and say, what did you do here? What did you do in this case? In none of these proceedings, however intense the public interest or acute the asserted security concern, did a court write a 10-minute window of public access into an order, and in none did a court, having set the terms of access, then deviate from its own order by withdrawing the overflow feed it had earlier provided. If you remember, in the thing when they first had stated it, it sounded like when they put it up for the jury selection, it sounded like the thing said, we haven't seen it yet. It sounded like the order said, it's like, this is the way it's going to be ongoing. And then the folks showed up and it was gone. Okay. It was only the TV or the overflow, whatever, was only there for the jury selection. That is what marks this case as an outlier rather than an example. The occurrence and public character of these widely reported proceedings are matters potentially subject to judicial notice, and the legal sufficiency of this ground does not depend on them. It rests on Waller, Stedman, Lilly, Presley, Cameron, and the Texas emergency orders already cited. The comparators confirm what those authorities require, that overflow seating, audio access, video feeds, and adequate courtroom space are the ordinary, big word there, means by which courts keep high-profile trials open, and that the court adopted none of them, confirming that its closure was neither narrowly tailored nor the product of the consideration of reasonable alternatives that Waller requires. They're talking about here. The same picture emerges from the trials the public has actually watched in recent years. The variable that set those proceedings apart was not whether cameras were allowed inside the courtroom. Some permitted and some forbade them, but whether the court supplied a reasonable alternative to exclusion, an overflow room, or a live audio-video feed. A camera in the courtroom is not constitutionally required, right? It says public. A reasonable alternative to closing the doors is. Every one of these proceedings supplied that alternative. I think they're referring to the chart below. This trial supplied no continuing overflow room and no audio or video access during testimony or punishment. The following comparison, offered for illustration only, sets those recognizable proceedings beside this one, okay? And I'm not going to read all those. The trial judge's own subsequent public statements confirm both the breadth of the closure and the availability of an alternative he declined to employ. In a televised interview after the trial, a recording of which is filed conventionally with the clerk as Exhibit 4, and a verified transcript of which is attached as Exhibit 3, the judge stated that his courtroom held, quote, 70 seats, end quote. that he had received, quote, 200 requests by media, end quote, and that the general public was left with only, quote, 27 to 32, public seats, that we rotated every day, end quote, okay? So if before the thing kicks off and you got 200 by the media alone and you only had 70 seats, right? You probably know you're going to have a problem, okay? It says it confirms that the press was accommodated. Oh, sorry. Figures that corroborate the declaration's account of roughly 27 public seats and confirm that the press was accommodated while members of the public were turned away. The judge further acknowledged that an audio feed was feasible, stating that he, quote, sometimes, thinks maybe he should have, at least, audio streamed or something so people could hear it, end quote. And that he declined to do so not for any reason bearing on the fairness of the trial or the safety of participants, but because, in his view, quote, people are going to distort whatever happens, end quote. And so, quote, what's the point, end quote. Offered as the decision maker's own account, these statements corroborate that the closure was broader than necessary and that the court rejected a reasonable alternative for a reason the public trial guarantee does not countenance. Step back, and the regime the order created has no precedent in Texas criminal practice. A standing trial-wide order rationed the general public to a single 10-minute entry window and roughly 24 rotating seats, capped attendance beyond a media allotment, barred re-entry once the doors closed, and after a brief experiment with an overflow feed during jury selection, switched off that feed for the testimony, all while the reporter's record of the trial remained untranscribed. The pretrial proceedings were not made part of any reporter's record available to counsel, and the case file sat in the court's chambers. No Texas court has approved such a regime. And the court's televised interview does not soften that picture, it sharpens it. Asked to account for the restrictions, the court did not point to a single record finding, an articulated threat, or a considered rejection of alternatives, the things Waller and Presley require, but defended the result as, quote, an easy decision, end quote. It had, quote, struck pretty well, end quote, and explained its refusal to even audio stream the trial on the ground that, quote, people are going to distort whatever happens, end quote. So, quote, what's the point, end quote. That is not the voice of a court exercising the, quote, special care, end quote, the Sixth Amendment demands before a courtroom is closed, per Waller. It does not supply the contemporaneous record-supported findings that the Sixth Amendment requires. Like, where's the proof? So they're saying, where's the proof that you needed to close this? The public trial right is not satisfied by closing the courtroom and explaining the choice on television afterwards. It is satisfied by findings, the consideration of reasonable alternatives, and by an open door. The judge's own statement of his purpose confirms that the closure was a deliberate denial of the contemporaneous public access the Constitution guarantees. In a written statement to Fox News after the trial, the judge explained, quote, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Excuse me. Now that the trial is over, it is important for me to provide transparency. And again, isn't that supposed to come before and during? Like, are we supposed to only have transparency at certain times? But the public trial guarantee secures the public's right to observe the proceeding as it happens. It is the contemporaneous openness of the trial, not a retrospective account offered after verdict and sentence, that assures the proceeding is conducted fairly and discourages misconduct. And they cite Presley and Waller. Transparency furnished after the trial has ended is no substitute for an open trial and cannot cure the denial of access while the proceeding was underway. The interest the judge invoked, protecting, quote, the process, witnesses, and jury, end quote, are, moreover, precisely the kind of generic non-particularized concerns that cannot justify closure absent specific findings on the record. They're going to quote Stedman. The court's own public information officer independently confirms both the breadth of closure and the existence of a simple alternative the court declined to use. By email dated June 5th, 2026, Steve Stoller, whom the 296 District Court appointed as the public information officer for this trial, explained the court's media and access process to a member of the public who sought to attend. Mr. Stoller confirmed that the courtroom held only, quote, about 70 seats, end quote, that the prosecution and defense each received 15 seats for family, that, quote, the judge allocated only 9 seats for the media, including one for a courtroom sketch artist, end quote, and that after court staff only, quote, about 24 or so seats for the general public, end quote, remained, so that the court, quote, had no choice, end quote, but to turn members of the public away. Most pointedly, Mr. Stoller stated without qualification, quote, there is no overflow room, end quote. Nor was the absence of an overflow room an ad hoc response to conditions that had emerged at trial. So they're saying it wasn't like something happened and then they took it away. By email dated May 25th, 2026, before the trial began, the public information officer had already advised an inquiring independent journalist that, quote, there will be no overflow room during the trial, end quote. This despite the county's own media request intake form, which listed, quote, overflow room access, end quote, among the accommodations that could be requested. The decision to deny the excluded public any alternative means of observation was thus made in advance of trial, before any trial day circumstance existed that could have justified it. The 15-seat family allotment the public information officer described was not how family access operated in practice. The defendant's own family was limited to 8 seats in total, so that the defendant's grandfather and aunts were excluded from this trial altogether. I don't know what happened between 15 to 8. I don't know. The discrepancy is not a conflict in defendant's proof. It is the proof. The written order disclosed no numerical family allotment, no public seat allotment, no defense family limitation, and no procedure for challenging exclusion. The public information officer's later 15-seat description and Ms. Toussaint's 8-seat account showed that material access rules were being administered outside the written order and outside open court. So what they're saying is they were still doing something different. Set beside the trial judge's own admission, the picture is complete. The judge acknowledged that an audio feed was feasible, stating that he, quote, sometimes, thinks maybe he should have, at least, audio streamed or something so people could hear it, end quote, and declined it not for any reason bearing on the fairness of the trial or the safety of the participants, but because in his view, quote, people are going to distort whatever happens, end quote. The court thus faced a courtroom that could seat only about 24 members of the public with, quote, no overflow room, end quote, and a readily available alternative, piping the audio so the excluded public could at least hear the proceeding that the court itself recognized and yet refused to employ. That is the opposite of the obligation to, quote, take every reasonable measure to accommodate public attendance, end quote, and it confirms the failure to consider the reasonable alternatives that Waller requires. These admissions do more than corroborate the breadth of the closure. They reveal the considerations that actually drove it, and those considerations cannot satisfy Waller. The first factor demands an overriding interest likely to be prejudiced by an open courtroom. The decision-maker's own account, however, locates the basis for the restrictions outside the record and outside any such interest in the volume of media attention and, by his stated reason for refusing an audio feed, in his expectation that the public would, quote, distort whatever happens, end quote. A desire to limit the public's ability to observe and judge a criminal proceeding for itself is not an interest that justifies closing the courtroom. It is the very harm the open trial guarantee exists to prevent. As the Supreme Court has explained, open proceedings exist so that the public may see how justice is done therefore, quote, it is difficult for them to accept what they are prohibited from observing, end quote. And I think that's true. If you don't know what's going on, all you can do is wonder and question, and right, a lot of the things that we do here, the folks on YouTube, the news people, in our houses, in our communities, when we don't know, all we can do is speculate and wonder, right? They talk about a desire to avoid public misunderstanding or distortion is not, on this record, the kind of overriding Waller interest that can justify excluding the public. It is one of the reasons the public trial right exists. The closure, therefore, fails the first and second Waller factors on their merits, not merely for want of adequate findings, and the resulting violation is structural. They're talking about it being foundational. Where the record fails to show that the trial court considered all reasonable alternatives to closure, the closure is reversible error. And they're making these quotations again. Let me just see how far. Yeah, they are going to town here on this one. Off-record administration by non-judicial personnel confirms that no Waller determination was made. The court could use staff, deputies, and a public information officer to assist with logistics, but Waller required the court itself to make the constitutional access determination on the record. That did not occur here. And let me tell you, I think they're throwing every possible thing in here, because I don't know if you know, it sounds like we keep saying the same thing over and over and over again. But they're probably trying to make, because they've numbered them and itemized them, they're probably trying to make specific points here. They threw everything, including the kitchen sink, in here. The amended order did not merely regulate decorum. It created a scarcity regime for a public criminal trial, limited public admission, space available seating, immediate cap, closed doors at 9 a.m., restricted reentry, no continuing overflow, and no audio or video alternative after jury selection. Yet the order did not disclose the number of public seats, the number of family seats, the standard for determining, quote, media, or any process for challenging exclusion. In practice, those decisions were administered through courthouse personnel and the court-appointed public information officer. The officer later described numerical allocations that do not appear in the order. Members of the public were turned away or removed under standards that do not appear in the order, and requests for alternative access were routed by email and denied outside any judicial proceeding. So, is the judge going to say the PIO should have fixed it? Or was the PIO going, right? Because when you have an order, you have a judge's order. But is the PIO going to say the judge told me to do this or whatever? Like, who knows? The resulting record does not show who was excluded, why exclusion was necessary, what standard governed admission, or what alternatives the court considered. Defendant does not contend that every logistical action by court staff is unconstitutional. The defect is narrower and more serious. Access decisions with constitutional consequences were administered off the record without published standards, without judicial finding, and without a reviewable ruling. That confirms the Waller violation. Defendant further preserves the argument that to the extent the amended order delegated the constitutional access determinations Waller commits to the court rather than mere logistics, that delegation was itself unlawful. Okay, we're going to stop here on this part because it's going to get into another portion of this. We're going to talk about the sealed records and all the stuff, right? They're just not arguing one point here. They're arguing a bunch of points. And I know you guys, I thought about stopping because it does seem a little bit redundant, but I started, so I'm going to continue it because they filed the entire pleading. And I think just like folks were precluded from the court, I think we need to understand line by line what the defense is alleging, right? Because every one of those counts, every one of those numbers is, in the defense's eyes, a potential reason for the new trial. Okay, so I think we have to be in line with it and just go through it however long that it takes. Okay. And then I think that the exhibits are there. So then we will take a look at the exhibits and go from there and see what it says. And I forget when they asked for a date. Was it August 21st? I think they asked for a date that they need a hearing. They need a decision by then. So then we'll have the answer. But we're going to continue to go through it. We'll continue it on the next one. Thanks for being here. I think this is very informative. All those case citations, case quotes, because we are seeing these issues brought up in the other trials. And now we know that we have a constitutional right, at minimum, in some form or fashion to get access to it, whether it's a larger courtroom, audio feed, video feed, or whatever. So I'm learning a lot. Hopefully you guys are too. And I will see you on the next one.